Practice and procedure. I will be discussing 4 subjects. Practice and procedure will be the first subject, and all these 4 subjects, for the convenience of persons who are writing the exam in 2017, it shall be on the basis of the 2016 paper, just to explain how it is done. And practice and procedure, if you see, there are 2 jurisdictions of the Supreme Court. One is the original jurisdiction and other is the appellate jurisdiction. And original jurisdiction encompasses the original jurisdiction under Article 131, then the transfer jurisdiction under Section 25 CPC and Section 406 CRPC and Section Article 139A. These are 3 jurisdictions under the transfer. They are also original jurisdiction. Then the writ jurisdiction under Article 32, and also the PAL jurisdiction, that is also under Article 32. And apart from that, the Article 131. These are the original jurisdiction of the Supreme Court. And the appellate jurisdiction is the extraordinary jurisdiction of the Supreme Court and the appellate jurisdiction of the Supreme Court. And the statutory appeals, that is under the Advocates Act, under the gold SIGAT, under conferred jurisdiction, statutorily conferred, under the Consumer Protection Act, and also under the Presidential and Vice Presidential Act. These are all statutory appeals conferred on the Supreme Court, not by way of the Constitution, but by way of special statutes. Mainly in Supreme Court, as far as practice and procedure is concerned, 2 areas are there. One is the original jurisdiction and the other is the appellate jurisdiction. Statutory jurisdiction, 5 marks, 10 marks, 15 marks question, 1 question will be expected. But the main questions will be from the original jurisdiction as under the Constitution and the appellate jurisdiction, extra appellate jurisdiction under the Constitution. Now let us start with the appellate jurisdiction of the Supreme Court. Appellate jurisdiction of Supreme Court is under Article 132 to 135. The civil appeals, the criminal appeals, both these appeals, in civil matters as well as in criminal matters, appellate jurisdiction of the Supreme Court would be exercised. And all these, it should be on the main important point, the difference between the appellate and extra appellate jurisdiction of the Supreme Court is that in case of the appellate jurisdiction of the Supreme Court, the appeal is against the final order of the High Court, that is under 132 and 133 in civil and criminal matters, final order of the High Court, and after the High Court gives a certificate of appeal under section Article 134A. So these are the basic conditions. It should be a civil or criminal matter, the final order of the High Court, and either the party on the order being given by the High Court should apply for the certificate of appeal, or the High Court on its own motion shall give the certificate of appeal, and on that basis the Supreme Court shall entertain the appeal under Article 132 and 133, and 134 is the certificate of appeal. In extraordinary jurisdiction, it is against any order, decree or judgment of any court, tribunal or forum. Only thing, it should be judicial of nature. The right decided should be of a judicial nature. That's the only condition. Otherwise, the Supreme Court shall entertain any order from any tribunal, court or forum. And that is the difference between the appellate and the extra appellate jurisdiction of the Supreme Court. Therefore, even interim orders are appealable. For that instance, the word any has clearly negatived any specific kind of order that shall be appealable before the Supreme Court. Any will be interpreted by the Supreme Court on the basis of the extraordinary nature of the appeal sought for. Therefore, it is a discretion of the Supreme Court, and there is no vested right. The Supreme Court shall decide whether there shall be exercise of power under Article 136. And there are other concepts. How it is exercised? How is the jurisdiction exercised? there is the ratio decidendi, there is the stare decisis, there is the doctrine of merger. These are all principles on the basis of which Supreme Court shall exercise its powers. So there shall be a quorum, and how the appeal shall be heard, it is under Article 145. So the power to make rules, Supreme Court rules are made under Article 145 clause 2, whereby the Supreme Court, with the permission of the President, has made its own rules. And from 2013, there has been a change in the rules of the Supreme Court, and new sections regarding curative petition, and certain inherent powers of the Supreme Court have been increased, and review also, with respect to review also, there have been marked differences after 2013. So certain provisions have been included, and provisions with respect to AOR, the basis on which they shall practice name lending by AORs. All these things are taken care of in the new rules, and therefore the rules are formulated by the Supreme Court, and on that basis the Supreme Court hears all SLPs by matter of majority. All appeals are heard by majority and minimum of 2 judges, and orders are given by the basis of majority principle. That is, the majority decision is the final order of the Supreme Court. Now, how it is binding on each other, stare decisis, that principle. See, extraordinary jurisdiction is a very large topic. It encompasses law declared by the Supreme Court. So it all boils down to what is law declared by the Supreme Court under Article 141. Law declared by the Supreme Court shall be binding on all courts of India. Therefore, law declared by the Supreme Court, how it is done? So this is these principles are: law declared is on the basis of majority, law declared is on the basis of the bench that is ordered by the Chief Justice of India, the roster, and it is heard, and once the jurisdiction of the Supreme Court under 136 is exercised, then the leave is granted, then the order, the law declared by the Supreme Court happens. So there is a appellate jurisdiction, there also law is declared, no matter, no problem. But in extraordinary appellate jurisdiction, the law is declared after filing of the SLP under 136 on the basis of substantial question of law of general importance, public importance, that needs to be decided by the Supreme Court being raised, and on the basis of such questions being raised, the Supreme Court entertains the SLP, and under Article 136 it grants leave to hear the matter. Then it is converted into a regular appeal, and all law declared by the Supreme Court is after grant of leave. So the leave should be granted. That means Supreme Court should decide there is a substantial question of law or a substantial question of public or general importance, so as to be decided under the extraordinary jurisdiction of the Supreme Court. And once the leave to hear that matter has been granted, then the law is declared. Therefore, that law that is declared by the Supreme Court of equal bench, that is a 2-judge bench law of earlier decision made by a 2-judge bench, is binding on a subsequent bench. So there is a law of precedence. Once a law is declared under Article 141, that shall also operate as the law of precedent, and such law declared by the Supreme Court shall be binding on Supreme Court itself, one thing. Second, all high courts and tribunals. Therefore, this is Article 141, and I told you the majority decision and how it is made, the roster, the Chief Justice, it is the organizational part of how the orders are being made, and the substantive part is the ratio decidendi. That is, the facts and the reasoning that are used by the Supreme Court to arrive at a judicial conclusion to a particular list before it. That is a ratio decidendi. So it is not the facts that are surrounding, that is outer way. It is the innermost facts and questions of law that together form the reason for the basis for the decision. That is a ratio that is discussed. So the Supreme Court's ratio is binding on all other courts in India, and the orders of the Supreme Court shall be enforced by all authorities, civil and other authorities, judicial authorities, by the and that is given under Article 144. Therefore, 136, 141 and 144. So this is the structural framework of how Supreme Court makes orders. And in this, there are several principles which we need to understand. The several principles are, as I told, the principle of ratio decidendi, the principle of stare decisis, and the principle of the substantial question of law. Now let us understand. So therefore, either the High Court should be convinced while referring it to the Supreme Court that the matter is of substantial question of law, of constitutional importance, of general importance, or some public purpose should be served. Under the High Court's own opinion, when it gives a certificate, it should be convinced. Or the person who is making an appeal against any order, if it is not the final order of the High Court under the Article 132 to 134, the person who is taking a particular order on appeal to the court should convince the court that the substantial question of law exists. That is the first requisite for attraction of the jurisdiction of the Supreme Court. So, substantial question of law. What is a substantial question of law? The Supreme Court has almost exhausted all areas of law and has settled law in almost all fields. But as we all know, law is dynamic, yet it cannot stand still. So, law cannot be static, law is dynamic and it cannot stand still. Therefore, the principle of dynamic approach and the principle of defining the contours and the outer limits of how a substantial question of law can be attracted is getting defined every day by the Supreme Court. So, substantial question of law, simply understood, is a question of public importance, of general importance, or of constitutional importance. And it is better if on that particular question there are several judgments of the High Court that need to be synchronized, and there is a conflict of several judgments of the High Courts on a particular question of law, and Supreme Court has also not given an authoritative finding on the interpretation of that question of law. This is the best situation where the Supreme Court entertains a particular appeal. That is, on being convinced that there is a confusion on interpretation of a particular question of law over several High Courts, and on there being an area that requires the clarity to be supplied by the Supreme Court. So, this area, if shown to the Supreme Court, then the Supreme Court will accept that SLP, that is a special leave petition, for praying for leave to appeal against the particular order on the basis of a particular substantial question of law. Then what happens? The leave is granted. All these happens under 136. From the moment an SLP is heard under admission head under admission section on a Monday or a Friday, to the moment when the final disposal is done, leave is granted and the order is pronounced and it becomes law declared. All these things are covered in only one article, that is Article 136, the extraordinary jurisdiction. So, there is a large scope of extraordinary jurisdiction, and the basic point for exercise of substantial question of law is for extraordinary jurisdiction is a presence of a substantial question of law. Therefore, I told you there should be confusion. That is one ground. Second is law is settled, but still, if the perverse interpretation of the particular one area is where law is not settled. So, what do we do if the law is settled and the High Court gives a perverse interpretation? Yes, in that case also a substantial question of law arises. Owing to a perverse interpretation or a wrong interpretation of a particular substantial question, then also there is a problem of the Supreme Court having to exercise its leave. So there are instances, it is not defined, notwithstanding anything. You must understand that Article 136 starts with the clause notwithstanding anything. That means non-obstant clause. That means in spite of any other controlling provision in the Constitution, the Supreme Court's power under extraordinary jurisdiction is a residual plenary power. It shall remain. Therefore, no other part of the Constitution or any statute can be meant to have controlled the power of the Supreme Court to take up any question of law or any cause or list before any High Court or the Supreme Court itself and decide it on merits. So that is the extraordinary power. It is a very widely undefined power, mainly because, why it is undefined? Mainly because the scope of interpretation should be left free for future issues that might arise. Therefore, such a wide power has been undefined and left to the wisdom of the Supreme Court judges, so that when the need arises, that particular notwithstanding, non-obstant clause shall be used to invoke the Supreme Court jurisdiction to 1. settled substantial question of law in a particular legal area, and to 2. to dispel any miscarriage of justice, any gross abuse of process of law in the interest of justice. See, these are the terms that are used by the Supreme Court to exercise its powers. They are general terms. You see, why they are general? Because you cannot restrict or be specific where a right is concerned. Therefore, the exercise of the right, the exercise of the jurisdiction to remedy a right. So, when there is a remedy, when there is a right, there is a remedy. Therefore, if there is the need to exercise jurisdiction, then Supreme Court shall exercise it, and the need can never be defined finally. Therefore, the needs are broadly fixed in these contours. One is, I has already told you, there is a need for the Supreme Court to interfere mainly because of a confusion in interpretation of law. That is the basic one. The second one is, I told you, there is a High Court decision, but it is not the question of law has not been properly interpreted as per law settled by the Supreme Court. Third is, as a result of such wrong interpretation, there is abuse of process of law, there is the interest of justice that needs to be protected, then there is the these are the abuse of process of law, interest of justice, and generally natural justice, basic natural justice norms, miscarriage of justice. In criminal law, miscarriage of justice and the prospect of there being any abuse of the rights of the innocent, that the innocent might be punished, grave injustice. These are all general terms, you cannot define them. Grave injustice, miscarriage of justice, interest of justice, ex debito justitiae. These are all the principles on which Supreme Court under 136 exercises jurisdiction. So you have to understand this. And now this principle you have to expand. One thing is, while you are drafting 136, civil or a criminal matter, then these are the principles that you have to show. Therefore, you must show that the High Court judgment is perverse because there is injustice being created, there is miscarriage of justice, the sentence is inappropriate, like that, on principles where there is a need for a remedy to the person. So, once that is shown to the satisfaction, the leave is granted and the Supreme Court exercises its jurisdiction under 136. Therefore, you must understand these articles 132 to 134. I already told, if the High Court certifies certificate of appeal on the final order of the High Court. Now 136 is not a final order, any order, and it is a plenary provision, it is a residual power of the Supreme Court, and there is no restriction on it, and I told you these are the grounds. Now after 136, how must you, then you must go to 141. 141 is stare decisis. That means the law declared by the Supreme Court shall be binding on all courts of India. That is 141. And I told you, this 136, 141 are exercised on the basis of 145 to Supreme Court rules. That is declared by the Chief Justice with the permission of the President, and they are controlling the manner in which the Supreme Court exercises its jurisdiction. Therefore, this is the link. And there is another section, 142. 142 is the power of the Supreme Court to do complete justice. Again, this is also a very vast and undefined power. Even though it is 142 is subject to statutory provisions. That means it cannot supplant the statutory provisions. In the SCB vs. Union of India and several other cases, the 142 was read down. You cannot supplant the statutory provisions to exercise 142. However, 142 is of great importance to do justice, complete justice. Therefore, 142 is exercised in 136, that is by extraordinary jurisdiction. It is exercised in 25, 406. It is read with so many provisions. It is read with Article 32 where you file a writ or a PAL. It is also all read with Article 137 where you file for a review of the Supreme Court. And also more specifically 142 is used in the curative petition. That is filed along with Article 32, read with Article 142 and the orders of the Supreme Court in Rupa Khura vs. Ashok Khura. Therefore, these are the articles which give the jurisdiction of Supreme Court. That is Article 136, you must always read it with 141 and 142 and 145. So, if you take up 136, automatically then you have to understand what is law declared by the Supreme Court, that is 141, and in case complete justice needs to be done, that is Article 142, and in case this complete justice and 136 is to be exercised, how it is to be exercised, that is controlled by the Supreme Court rules. Therefore, the substantive part of the powers of the Supreme Court are dealt with under the Constitution provisions. That is starting from Article 141-24, the Union Judiciary, to Article 145. So, these 21 articles you must be thorough. The main key provisions in every article you must be aware. Therefore, you must understand them, how to apply these articles. Then, okay, now you are thorough with the 21 articles, 124 to 145. Then you must apply the rules. Rules are nothing but minute. See, macro level application is Article 124 to 145 in the constitutional side. It encompasses the original and appellate jurisdiction of Supreme Court. And rules is micro level application. See, filing, it controls the filing, it controls the listing, it controls the any condemnation of delay, any implement of legal representatives, any intervention, any substitution application. These are formative and procedural aspects are controlled by the rules, and substantive aspects are controlled by the Constitution. So, you must a practice and procedure exam has a ringside view of both these aspects. So, 50 marks they are telling is Supreme Court rules. It's also one of the easiest exams because, see, Constitution is only principles. I had told you law declared, extraordinary jurisdiction, leave granted. These are the principles, substantial question of law, then appellate jurisdiction. These are broad principles, notwithstanding non-obstant clause. These are broad principles. And you have to follow it up with exact micro level rules. And I tell you, so far as the constitutional important key terms from 124 to 145, so far as the rules, you must memorize them. You have to write it down and somehow you have to develop a means of memorizing these principles. This is memorizing. Then there must be a very good understanding of the sound basis of these principles and how they are applied. This understanding will help you in the drafting part. So, if you are going to draft, unless you are confident of the principles, you cannot draft. Therefore, it is a mixture of the drafting part and the conceptual understanding part. This is required in the practice and procedure paper as well as the drafting paper. Therefore, if you are going to draft an SLP, you definitely need to know how the complete justice is done. You definitely need to know what is the interest of justice, what is the miscarriage of justice, what is the abuse of process of court. All these things you must know and try to have citations on that. So, I have told you now 132 to 134, 136, 130, 141 and 142 and 145. Now, let us go to review. So, I have broadly discussed with you the part of appellate and extra appellate jurisdiction. Now, we will go to the review jurisdiction of Supreme Court. That is 137. Review is in civil and criminal matters. In civil matters, review is on the basis of Order 47 CPC. That is, first thing about review is it is a very, very extraordinary provision. It is not a regular hearing of appeal all over again. The Supreme Court, while it granted leave or while it dismissed a matter indemnity under 136, whatever it might be, on admission or after granting of leave and final disposal, Supreme Court had already appreciated, fully heard the matter and gave the order. Therefore, when you are appealed against the Supreme Court order by way of review, the review or the provisions, the scope of review is very, very limited. One is if there is any miscarriage for criminal matters, if there is a likely chance of a miscarriage of justice or a grave error, then criminal matters they will accept. In civil matters, it is specifically restricted to Order 47 of the CPC, Civil Procedure Code. Whatever grounds that are available under Order 47, they are available here also. That means any important point that was to be made was not available with the petitioner and needs to be made. So that's grave injustice is not done. That you have to do it within 30 days. The minimum time is 30 days. Within that, you have to bring it to the notice of the court and place it and ask for review. And that point, if made, would have made the difference. That means order could have been otherwise. Though that is one thing. So review is this. Let us go to the provision itself. I was discussing about review. I was telling that Article 137, two areas, civil and criminal matters. In civil matters, it is exclusively as per the grounds that are specified under Order 47 of the Civil Procedure Code. That is, one is when a particular point was not made aware owing to several reasons, sufficient reason shown to the court by the petitioner. Therefore, there is a need of placing that point on record, and that point, if placed, additional facts if placed, would have made the difference in the order of the court. Then there is the question of review. The other point is sufficient reason being shown. That is discovery of a new and important matter of evidence which was there but not within the knowledge of the petitioner and could not be placed, and the other is the error apparent on the face of the record. Therefore, it is these are the two grounds. One is a point that could not be placed, and the other is the error apparent on the face of the record. Therefore, it cannot be any 137 is not a rehearing of the case all over. It is not an appeal. It is merely to correct errors. See, if there is a error that is very, very basic, striking error, typographical error, clerical error, or some documents that were wholly not appreciated, then there is a error apparent on the face of the record that should appear to the court immediately on the first reading, prima facie. That is ground for review. The other is any point that could not be made because of bona fide reasons, and there is sufficient cause, sufficient reason for such a mistake or error being committed. That is why it could not be placed. These are the two grounds. And the other is to, in criminal matters, it is to prevent miscarriage of justice. It is not a, it is to prevent miscarriage of justice. There must be some justice delivery failure. So these are the grounds for civil and criminal review jurisdiction to be exercised. And now there is a second review petition that was has now recently been included in death sentence matters. And now Supreme Court, when it dealt with the death penalty cases, where death penalty is given by the Supreme Court and it's going to be executed, the party can prefer a second review petition on the death penalty and the execution, just because life is going to get over and you can never come again. Therefore, in case there is any substantial injustice in the sentence or in the conviction, and the sentence needs to be commuted, or the sentence is excessive, then Supreme Court can always give one last time for the death sentence convict, and that is a second review petition. That was that principle was enlarged by the bench of Honorable Justice Nariman, R.F. Nariman. I think Shabana. All these cases you have to find out. I am only dealing with the principles. I will be discussing later a case, but now at present principle. You check out the case. These are homework you have to do. This is a basic overall understanding of the subject, and therefore these are the, and you see in review certain important case laws are there. P.N. Ishwaraiyer, in so far as criminal review petition is concerned, it's a landmark judgment. P.N. Ishwaraiyer's case, that was when in a criminal matter how a review jurisdiction can be exercised. Therefore, that is 137. Now, after 137, there is this. These are all appellate jurisdictions and review. And now there is this 143. 143 is the advisory jurisdiction of the Supreme Court. Supreme Court, this advisory jurisdiction is in the original side. Supreme Court shall advise the President of India, may. It is optional. In matters that are theoretical or hypothetical, or involves disputed questions of fact, Supreme Court won't give an advice. If it so thinks, that means the President can, if he is satisfied there is an existence of a particular matter of public importance that needs to be decided or that needs to be appreciated well in the interest of public, the President can refer the matter by way of a reference to the Supreme Court, and the Supreme Court may give an advisory opinion on that. It is not shall. The Supreme Court may give an opinion, and I already told that it should not be already judicially decided by the Supreme Court. If it is judicially decided, that is final. It is not a appeal. For example, this is a very famous case law. What happened in the public interest litigation filed by Prashant Bhushan CPIL, that case regarding the allocation of natural resources by way of auction. There was a landmark judgment of Supreme Court that the allocation of natural resources shall be by way of auction only. And immediately after that, there was a reference by the President of India.